Good morning. The, the curtailment of fundamental rights begins when the person is arrested. Then question arises when he is remanded to judicial custody and police custody. Thereafter, conviction, sentence, undergoing sentence, pending appeal. Then suspension of sentence. Thereafter, when this appeal and Supreme Court special leave petition and filing appeal under criminal enlargement of criminal appeal act, Supreme Court Act deals with the criminal appeals. Then question arises: the detainee must have parole, leave, and parla. What is the difference between parole and parla? Parole means they will leave the detainee, the convict, for certain period by putting certain conditions. Parole means the escort will always accompany. Leave means grant of leave. It's just like parole. See, that was a case where has been referred, and in the year 1982, some relaxations were granted, some rules were framed, just like treating the convict as a government servant. It's all right, had happened. After all, we are on one hand deterrent punishment, retributive theory, another reformative theory deals with criminal law, criminology. Okay, this is most important judgment. Young lawyers, particularly criminal side practitioner, and those want to be more familiar in their area or segment of society, must kindly go through the judgment, and I hope the judgment may be subject to approval of the apex court because it involves in general importance. AR 2022, Madras 69, full bench. Justice Munishwarnath Bhandari, Chief Justice, C.J. Pushpa Satyanarayanan, and P.D. Ajikesar. They say word conjugal rights. Conjugal rights, what is conjugal rights? We normally file petition before the Hindu marriage and section 9 for conjugal rights. In all personal laws we can file. Mutual rights of companionship is a conjugal rights, section 9. Then they are deal with section 432(5), TN suspension of sentence rules, 1982. Extraordinary leave, meaning word extraordinary read in conjunction with the word reasons, makes it clear that reason should be beyond what is usual, regular, or common. That is so logically you should understand. Then they say undergoing fertility treatment, infertility treatment, in a circumstance when the convict has no child from the wedlock from extraordinary reasons for grant of leave. They say for this operation also you can seek leave on ground of extraordinary leave. Then they say Constitution, Article 21, denial of conjugal rights to convict for specific purpose like undergoing infertility treatment may amount to denial of fundamental right. But they say, but it should not be construed to be a fundamental right for having conjugal relationship as a course. This would make a difference between law abader and violator in regard to rights guaranteed under Article 21 of the Constitution. For what purpose they have given this ratio, I do not know. Whatever it may be. Then they say emergency leave or ordinarily recused by convict for the purpose of having conjugal relationship with the spouse. State can be directed to consider recused favorably for the purpose of undergoing the treatment. However, emergency leave or ordinarily cannot be claimed as a right for having conjugal without an exceptional reason. I don't know what they want to say. It's all right. We can't say more than that, but definitely I would say that he is an accused involving in the bomb blasting case. So many things are offences committed. So let us not discuss about. Then you must go through the paragraph 8 They say leave is not a right, ground for grant of emergency leave, eligibility for emergency leave. All this you must take or read or take copy if you are not having these rules, so that if anybody approaches for grant of leave, you can go through these rules again and apply for leave. Non-eligibility for ordinary leave. These things are there. You go through all these things up to paragraph 8 is totally important. Then the definitions. Then they have discussed about what is extraordinary leave. Then also they have discussed about English dictionary, Oxford Dictionary, about what is extraordinary. It's all are logical. Finally, they say they direct the state to reconsider the request of the Congress for this purpose. So I don't want to give opinion about this. Let the apex court decide what to do, what not to do. However, relief was granted to the convict for a different purpose, somewhat a new subject, new topic for this. Okay, let us welcome this transformation of law. I hope you understand my feeling. Not about the accused, but the concept. But what about whether the grave offender convict wanted to procure a child at this later stage of age, and the courts permits them to have that right as a fundamental right. Whether this is sustainable before the apex court, because Supreme Court must admit this case because of its general importance, not yet decided by any other court. Therefore, definitely they would have their hand to open the file. Best wishes.